Welcome to our YouTube video series on wills and estate planning. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we'll be discussing aspects associated with why you should have a will, or the reasons for having a last will and testament. Well, first and most important reason for many people is the fact that you, as the writer of the will, or in conjunction with a lawyer, is going to determine how your estate is distributed upon your death. So you are making the decision, not someone else, and not that being not the courts, not a judge who's unfamiliar with what you want and you don't want, and not some directive that's coming down from a statute or other regulation of government which sets out a structure that may not be consistent with what you would desire from your estate when you are gone. Another important aspect is that you'll make the determinations as to how your minor children are taken care of, specifically who will be the guardians, and also how they will inherit your estate if they are to inherit it. One of the reasons you do this is oftentimes, especially where you have a larger estate, but irrespective, you don't necessarily want to drop the entirety of your estate or the proportion that's going to your children upon them at, say, the age of 18 or 22. Instead, you have a structure so that you could, even though they consider themselves to be mature, you can have a structure where payouts are done over an interval period. So it might be done part at 20, part at 25, part at 30, and the balance at 35. Remember, it's your money, so you get to make the determination. Naturally, when you do these structures and we talk about payouts, we're doing payouts that are above and beyond what's needed to maintain that child from the perspective of their health, their livelihood, their education. Those things come first. That money gets paid out as need be, and it's really just a balance, to the extent there is a balance, that will be paid out as cash payments on this structured arrangement. Another aspect that you're going to want to consider avoiding is the probate process. And the probate process is time consuming, can involve lawyers, can fray people's decisions, and need you to go look at what the law says, and people fight about it. First of all, with respect to a will, you're dead. So they can blame you, but you're dead anyways. So go ahead, blame the dead person. The one thing you don't want to necessarily be doing is have your children or your children and your spouse having fights between them and having your death be the source of acrimony that could have easily been avoided. Likewise, you don't want to have this process drawn out, have lawyers fighting about stuff, just charging your estate and lessening the amount of money that's available, and using different angles for people who you don't necessarily think should be deserving, trying to fight for what they are legally entitled to based on what the law is, and the law is not particular to anybody's particular situation. Similarly, to the extent there are taxes payable or charges payable, you want to minimize or avoid them to the optimal ability that you have. Next, you want to be determining who is overseeing your estate in your death. You don't really want to pass it on to some court-appointed person. They might be from your family, they might not be. If they're not, they're probably going to take a fee. If they are from your family, first of all, they have to go through the courts to get approved, which is time-consuming and costly. but they may not be the person who knows what you want best and who you would want to have appointed. Instead, it's best to go and identify the person or persons you think are the most appropriate. Those persons who have the most financial acumen. And then similarly with respect to guardianship, the person you think is best suited to raising your children if you have minor children. You want to be doing those appointments where possible. You don't want to let it be arbitrarily decided by someone other than yourself if it can be avoided. Similarly, you also, if there are people who you feel it is appropriate are not a party to your life when you're alive, should not be a party to your estate after your death. Yes, there are some limitations in that, and a knowledgeable lawyer will go over that with yourself. Nevertheless, what you might want to do is technically disinherit somebody. And if you're going to disinherit somebody, that is your decision. It is your decision. If you want to make disproportionate offerings to different people, such that a child who has mental challenges, physical challenges in life, gets a larger stake because they're going to need it more so than your child who is successful, well-educated, well-off. That is for you to make the decision, as opposed to simply allowing some foreign process, in many respects, the court system, dictate to say, well, there's two of them, 50-50. There's nothing right here that says this child struggles more. You might want to put controls on certain children. Let's say a child has an addiction. Let's say a child has a propensity to do things wrong, get into bad relationships. You might want to put in specific controls with respect to that child. But you cannot do that if you don't put it down in the will. Because then the executor and trustee of your estate has to go by what the court says, and the court really doesn't look into these nuanced aspects of family life, because the nuances could go one of many different ways, and that's not their job to balance them out. But you can, hence why you should have a will. Also, you can make specific gifts, donations, identify who you want your money going to. I address this in particular when people have finished off family members. Yes, in most cases, you'll have sufficient family members to inherit the bulk of your estate, if not all of it. But there are instances where people don't have much in the way of family, or all their family has predeceased them. So where is the money going to? Well, in truth, if there is nobody available to take the money, then it typically goes to the government. And although the government is important for us, I don't believe most people really want, at the end of the day, the government to take all their estate if there's no one or no charity or society that they would rather have it going to. But without a will, it will not go to who you designate. You want to have a clean process that is consistent with what you are looking at and what you want. And you want to be able to change it. Wills are easy to change, especially in today's day and age. There's the aspect of using a codicil to change it. Or if you go back to the same person who drafted it, often a lawyer, with the fact that most of these wills are saved in the system, it's very easy to change it from one day to the next when circumstances change. But it is also important that you deal with it now, because if you don't deal with it now, not only might you be dead and not have the opportunity at a later date to deal with your will, but if you are mentally incapacitated and not able to make rational decisions, whether you get into a car accident or you come down with a sickness, you may not be capable of making the determinations satisfactory for a legal determination and judicial oversight. So what happens then? Well, you don't have any will. It goes to the courts, and nobody knows what your determination was. Hence, why we strongly advocate for everyone having a will, because a last will and testament is extremely beneficial to you and the beneficiaries of your estate that you determine and not somebody else. Thank you. I hope you found this YouTube video informative. It only touches upon some of the central aspects associated with a last will and testament. Naturally, there's a lot more involved, and for that very reason, you should go and engage experienced legal counsel to assist you with the process of having a last will and testament that is appropriate for yourself, as well as powers of attorneys and personal directives, which deal with matters pertaining to your incapacity while you are still alive, which is something that your will is not really designed to do. Once again, thank you.